Welcome to Tully Rinckey's series of continuing legal education classes. I think you all have received a little folder binder that has the CLE schedule in there of the rest of our CLE programs for the next few months. About your presenter, that would be me. Most of you, or at least quite a few of you, were here, I think, in February when we did the traffic offenses. For those of you who weren't, my name is Tom Carr. I'm one of the partners here at Tully Rinckey. I'm a former assistant district attorney in Kings County, Delaware County, and Rensselaer County. I've also worked at the New York State Capitol as a assistant minority counsel and as also deputy legislative director and legislative director over there. And my practice here at Tully Rinckey is concentrated 100% on criminal defense. Among other things, I'm also a New York State Division of Criminal Justice Services Municipal Police Training Council certified police academy instructor and a certified firearms instructor. Okay, what we're going to be talking about tonight is criminal possession of a controlled substance, criminal sale of a controlled substance, and also drug paraphernalia and related issues. We'll start with criminal possession of a controlled substance. We're going to go over some definitions that you will come across in most of these cases. We'll cover the different degrees of criminal possession, and lastly, the penalties for the charges. First of all, some definitions. The definitions are contained in the Penal Law, Section 220.00. And the first one is the one that I think most lay people have a problem with. Anyone thinks of selling something means you give something to somebody else and they give you some money in exchange. You do not need to have that kind of a transaction for a controlled substance charge, either possession or especially for sale. Under the Penal Law, sell means to sell, exchange, give, or dispose of to another, or to offer or agree to do the same. I can't tell you how many times in my career I've had clients who are arrested and charged with drug offenses say to me, "I never sold him any drugs." What did you do? Well, I handed him the drugs and then the cops came in, but he never paid me for it, so I didn't sell it. Wrong. The other, I think, unusual aspect of the definition of sale here is that you don't even have to hand over the drugs. As long as there's an offer or an agreement to do the same, then that's sufficient to constitute sale. So, to put that in practical terms, if I called you up and said, "Hey, I've got a bag of hydrocodone, do you want it?" And you go, "Heck yeah." That constitutes a sale. We didn't meet face to face. I didn't give you the drugs. I may not even have the drugs. But just constituting that offer, that agreement to hand over the drugs is sufficient to meet the definition of a sale. Controlled substance, I'm not going to go through all of this, but in the public health law, 3306 of the Public Health Law lists what is and is not a controlled substance. There's going to be 4 different definitions, all relating to drugs. A controlled substance, marijuana, narcotic drug, and narcotic preparation. They're all listed individually in the public health law. Although not generally treated in the same way as other drugs, marijuana is included in 3306 of the Public Health Law, but marijuana offenses are dealt with in Penal Law Section 221, not Section 220. And in a wonderful case of stating the obvious, marijuana means marijuana. It also means concentrated cannabis. And again, you'll find those definitions in the Public Health Law. Narcotic drug is those listed in those schedules 1B, 1C, 2B, and 2C, other than methadone. And narcotic preparation, which is different than narcotic drug, means that any controlled substance listed in schedules 3D or 3E. Something else you're going to run into is sale on or near school grounds. School grounds doesn't just mean the school building, it means any of the athletic fields, any of the playgrounds. It can also mean school bus. Anything within 1,000 feet of the real property boundary line of a school also constitutes school grounds, even if it's out on the street. And one of the important factors there is an area accessible to the public, as opposed to a transaction taking place within someone's home that may be, 895 feet away from the school. So it has to be an area accessible to the public. There are two presumptions in the law dealing with drugs. And the first one I'll go over is the automobile presumption. What that means is if the police pull over a car, and there's 4 people in the car, and they find some cocaine in the center console, each of the 4 people in that car is presumed to have possessed that cocaine. What that means is each of those 4 people will be arrested and charged with possession of the cocaine. Now, if it's a taxi cab, the driver is not going to get charged. The other thing is that in terms of, going back to the scenario of 4 people in the car, if the cocaine, instead of being in the center console, is in the front pants pocket of one of the backseat passengers, well, now that backseat passenger is the only one who legally is presumed to possess those drugs. So the other 3 people in the car should not be getting charged based on the one guy in the back having cocaine in his pocket. It is a presumption, which means that if your client is in the car and the drugs are in the center console, but your client had no reason to know that the drugs were there, and you can show that he was unaware that the drugs were there, then the presumption can be rebutted. The other one is the room presumption. Similar to the automobile presumption, except it relates to drugs in open view or in plain view in a room. Now, this has been expanded to a certain extent in the case law. Let's say you have an apartment building, or an apartment itself, I should say. And in the living room, there is a coffee table in the middle of the living room, and there's a pound of heroin sitting on the table when the cops come in to execute a search warrant. There's 2 people that do not live in the apartment. They're in the living room. You have another person who does not live in the apartment, and he's in the bedroom. Most likely, that guy in the bedroom is still going to get arrested and charged with possessing the heroin that was on the living room table, even though he's not in the same room. As you can see, it says in open view in a room other than a public place. Even though the guy's in a different room, because he doesn't live there, it's going to be presumed that he had knowledge of the presence of the heroin in the living room. Obviously, the exceptions to it are if someone is authorized to possess the controlled substance, then that's okay, as long as they're the ones that possess it. It has to be in the same container as when they received it. In other words, let's say you've got a prescription for Xanax, and instead you go to the pharmacy and you get the prescription filled, and you get the little brown bottle, and it's got the label on it, and it's got your name on it, it's got the doctor's information on there. Well, you don't like carrying the whole container of pills around on you, so you put them into, you're going to work the next day, your prescription says take 2 pills a day, so you take one in the morning, you put another pill into an envelope, you shove it in your pocket, you go to work. It's no longer in the same container as when you receive possession of it, so technically you're violating the law. While you're authorized to possess it, you had a prescription for it, it's not in the original container. And I've seen this quite a few times. Usually that winds up with the person being arrested, charged with possession of a controlled substance. By the time it winds up in court, you bring a copy of the prescription provided to the ADA, and most of the time, assuming that there's nothing else going on, that's sufficient to have the case gotten rid of. Okay, now we go into possession of a controlled substance, the actual different degrees of it. The lowest one is possession 7th, which is an A misdemeanor. It goes possession 5th, 4th, 3rd, 2nd, and 1st. There's no possession 6th. And anywhere it says PC, that should actually say PL for penal law. But I guess when Melanie was typing this up, she couldn't read my handwriting. That's why she's wrote down PC. Like I say, from lowest to highest, it goes from the 7th degree to the 1st degree. There is no 6th. Not surprisingly, I guess the legislature can't count. Let's start with possession 7th, 220.03. It's a Class A misdemeanor. A person is guilty of possession of the 7th degree when you knowingly and unlawfully possess a controlled substance. Remember the definitions again. Controlled substance different than a narcotic drug or a narcotic preparation. Maximum penalty is 1 year in the local county jail, or probation, or misdemeanor drug court. Misdemeanor drug court, the way the drug courts operate, the person is normally put on a term of probation. For an A misdemeanor, probation is 3 years. For a B misdemeanor, it would be 1 year, and for a felony, it would be 5 years or more as we get up to the Class A1 felonies, the Class A2 felonies. Now we're heading into felony land. Possession 5th, possession with the intent to sell a narcotic preparation weighing a ½ ounce or more, phencyclidine weighing 50 milligrams or more, cannabis preparation or compound weighing a ¼ ounce or more, cocaine weighing 500 milligrams or more, ketamine weighing 1,000 milligrams or more, or any amount of ketamine if you've previously been convicted of possessing ketamine, and GHB weighing 28 milligrams or more. One thing to note, and you'll see this throughout Section 220, they constantly refer in different weights. Some things will say ounces, some things will say milligrams, some will say grams. They change back and forth between metric and imperial measurement. which there's no real rhyme or reason to it, except that when you get into the milligram ones, it's the small, really small amounts of drugs. And that's why they use milligrams. It's just more convenient than saying, 1/64 of an ounce or something like that. Maximum penalty on possession fifth is 2.5 years incarceration, in other words, state prison. Probation is an option. Drug court is an option, again, which would be supervised through a term of probation. Possession fourth, C felony, possession with intent to sell a narcotic drug 1/8 of an ounce or more. Methamphetamines, which weren't in possession third, are now listed here, 1/2 ounce or more. A narcotic preparation, 2 ounces or more. As you can see, a narcotic drug, 1/8 of an ounce, narcotic preparation, 2 ounces. The preparation is more watered down, essentially. There's going to be other fillers in there than there would be just in a straight narcotic drug. A stimulant, LSD, hallucinogen, or a hallucinogenic substance. All of those, possession fourth. Dangerous depressants or depressant, concentrated cannabis, phencyclidine, methadone, obviously methadone without a prescription. Maximum penalty, 5.5 years. Probation is an option, as is drug court. Now notice, once we get into possession fourth, now it's possession with intent to sell any of those. It's not straightforward possession. It's possession with intent to sell. Obviously, if a person was caught selling, they're going to be charged with sale. But the possession with intent to sell is based on the amount of the drugs that someone possesses. So if the weight of any of the drugs that they have exceeds the minimums there, it's going to be presumed that the person possessed that amount of drugs because they intended to sell it. Possession third, 22016. Now we're up to a Class B felony. Again, with intent to sell. The weights have gone up. Well, the weights have gone up, and also for the stimulant, hallucinogen, and LSD, it's also, if you've been previously convicted and you're caught a second time, then it goes from a C felony up to a B felony. For everything else, pretty much the weights are increased over a Class C felony. Maximum penalties up to 9 years incarceration. Probation is still an option, as is drug court. Now, I have to say, what I've listed here are the maximum penalties. It would be extremely unusual for someone with no priors to get anything up to the max. In most of the charges we've gone over so far, a person who is convicted on a first offense, if they have a drug problem, they're going to get drug court. Unless they've got some kind of a prior conviction for violence, they're going to get drug court. Possession second, Class A2 felony, where someone possesses preparations containing a narcotic drug 4 ounces. Methamphetamine preparation 2 ounces or more. Stimulant 10 grams. LSD 25 milligrams. Hallucinogen 25 milligrams. Methadone 2,880 milligrams or more. Note, the language has changed. Now it's back to possesses. It's not possession with intent to sell. Maximum penalty, 10 years incarceration. Lifetime probation. In all of the other prior felony convictions, probation would be for 5 years. But on an A2, it's a lifetime. And possession in the first degree, Class A1 felony, where someone possesses 8 ounces or more of preparations containing a narcotic drug, twice as much as an A2 felony. Methadone, 5,760 milligrams, again, double the A2 felony amount. Maximum penalty, 20 years. They doubled the maximum incarceration. No probation allowed. Now, for those of you who don't deal with drug cases on a regular basis, these may seem like small amounts. We're talking about 10 milligrams here, a quarter ounce there. In normal everyday life, these are minuscule weights, but in terms of drugs, that's a heck of a lot of drugs. Once you get to 8 ounces, we're talking about a lot of drugs. Any questions about possession so far?
We had the intent to sell aspect of them in a lot of these. Does that come from just the weight, or is there an extra element that the prosecution has to prove?
It can come just from the weight. For instance, a lot of times you'll see the intent to sell ones coming out of search warrant cases, where without necessarily an actual buy from a location, but observation of a quote-unquote known drug location, a large number of people entering and exiting within a short period of time, spending no more than a couple of minutes inside, frequent complaints from neighbors, etc., that gives the police cause to begin with to start monitoring the location. They get a search warrant, they go in, they find a lot of drugs. They can't charge a sale unless they have, evidence of an actual sale, but by virtue of the weight of the drugs located, they will usually charge possession with intent to sell. Another way that it's handled is, let's say you have a car stop, an automobile stop. Someone's coming up 787, they get pulled over for failure to signal. The cops approach the car, conversation ensues. Maybe they smell marijuana from the car. Maybe they have a canine that walks around the car and alerts. In some cases it's as simple as the driver is driving on a suspended license and he gets arrested. Now they have a right to do an inventory search of the car because the car has to be towed. They find 8 ounces of cocaine in the trunk. Well, 8 ounces is a deadly amount for one individual to consume. So the presumption is going to be that that was possessed with the intent to sell. So in a situation like that, the intent to sell charge would be used, but not the sale. Okay. If you could show that they planned on having some wild party that weekend, then you'd still have the intent to sell, but
wild party by themselves, or to be not intent to sell?
I think that would probably give rise to a detention under the mental health law. Okay, let's go on to sale of a controlled substance. Go through the different degrees and additional ones like sale to a child, and also I think we've got sale with the school, within a school zone, and then the penalties. For criminal sale, the lowest level is a Class D felony. Now for possession, the lowest was a Class A misdemeanor, but for sale, there are no misdemeanor sale charges. In fact, the lowest listed is a Class D felony. So potentially that could be lowered on an attempt 110-220-31 to an E felony, but even then you're still talking about felony and not about misdemeanors. Okay, let's start with sale fifth, which is a D felony. Very simple. Knowingly and unlawfully sells a controlled substance. Maximum penalty, 2.5 years incarceration. Bless you. Probation is allowed. Drug court is a possibility if the defendant is selling to support their own drug addiction. The drug courts are very reluctant to put drug dealers into drug treatment, or put them into a drug treatment facility, or allow them into drug court, because, you know, you're putting, well, talk about putting the fox in the hen house. You know, you're putting a dealer in with a group of people who all have a drug addiction. So they're very, very reluctant to do that. Only in the case of where they feel that the person is selling to support their own habit will they entertain drug court for someone convicted of sale. Possession fourth moves up to a C felony. Knowingly and unlawfully sells narcotic preparation, a dangerous depressant, 10 ounces or more, concentrated cannabis, phencyclidine 50 mils or more, methadone, ketamine, 4,000 milligrams. On school grounds or in a school bus, a controlled substance. Bear that in mind, because we're going to see separate charges later on for sale on the school grounds. GHB, 28 grams. Maximum penalty for sale fourth, 5.5 years. Probation is allowed, but again, because we're dealing now with higher amounts, it's going to be presumed that the person is selling for profit rather than selling to support a drug habit. So the higher you get on the sales, the more unlikely drug court becomes, which is why I left it out of sale fourth, third, second, and first. Sale third, B felony, knowingly and lawfully sells a narcotic drug, any amount. Stimulant, hallucinogen, or LSD, and you've got a previous conviction for selling any of those or for attempting to sell any of those. No weight needed there. Stimulant, 1 gram or more. LSD, 1 milligram. Hallucinogen, 25 milligrams. Maximum penalty on the B felony, 9 years. Probation is still allowed. Again, no drug court. Moving up to sale second. Knowingly and lawfully sells preparations containing narcotic drug, 1/2 ounce or more, methamphetamine preparation. And remember, these definitions of preparations, we talked about them earlier and they're included in your packet there. 1/2 ounce or more, stimulant 5 grams, LSD 5 milligrams. Like I said, it's an A2 felony. Maximum penalty, 10 years. Lifetime probation. We go to the A1 felony, knowingly and lawfully sells preparation containing narcotic drug. Obviously here the weights are increased. Maximum penalty, just like the A1 felony for possession, 20 years incarceration. No probation. Probation is not allowed on an A1 felony. Now, despite language earlier for criminal sale of a controlled substance, fourth, which mentioned knowingly and unlawfully selling a controlled substance on school grounds or in a school bus. There is a separate, under Penal Law 22044, criminal sale in or near school grounds. It's a Class B felony, where an individual knowingly and unlawfully sells in or near school grounds a controlled substance in violation of criminal sale fourth or criminal sale third on school grounds or in a school bus. School also includes a child daycare facility or any kind of educational facility. Maximum penalty, 9 years incarceration. Probation is allowed. Just to make sure the bases were covered, that you couldn't sell in a school, near a school, on a school bus, the legislature came up with criminal sale of controlled substance to a child, regardless of where that child may be. It's a Class B felony, where a defendant over 21 years of age sells a controlled substance to a person less than 17 years old in violation of criminal sale of controlled substance third and or criminal sale of controlled substance fourth. Now, what's notable is the way they wrote the age limits. The seller has to be over 21 years of age. So in other words, if you have two high school students and one of them raids mom and dad's medicine cabinet and takes some, I don't know, Xanax, brings it to school and sells it to his buddy who's the same age as him, they're not going to get charged under this section. Maximum penalty on the B, 9 years incarceration. Probation is allowed. Okay, drug paraphernalia. Let's go over this real quick. You have criminally using drug paraphernalia and criminally possessing a hypodermic instrument. Let's start with the drug paraphernalia. It's an A misdemeanor. It's where someone knowingly possesses or sells, and the definition of sell under this heading is the same as for possession or sale. In other words, giving it away is considered a sale. Dilutants adapted for diluting narcotic drugs or stimulants. Gelatin, capsules, glassine envelopes, in other words, any of the packaging that's normally used to package narcotics. Scales and balances. Now, obviously, your bathroom scale isn't going to count. So it's okay to go Bed Bath & Beyond, buy a new scale and bring it home. You're not going to get arrested and charged with criminally using drug paraphernalia. We're talking about those small little digital scales that weigh down in as low as grains. And obviously with an A misdemeanor, the maximum penalty is up to 1 year in the local county jail, or probation, or drug court if the person has these for their own use. Okay, so that was criminal using drug paraphernalia in the second degree. Going up to the first degree, we go from an A misdemeanor for the second degree, jumps over the E felony, goes right up to the D felony for using in the first degree. And this is where a person commits criminally using drug paraphernalia in the second degree and has a previous conviction for it. Maximum penalty is 2.5 years incarceration, probation, theoretically, drug court would be a possibility. Criminally possessing a hypodermic instrument, also a Class A misdemeanor. Knowingly and unlawfully possesses or sells a hypodermic syringe or a hypodermic needle. Now, the key word there is unlawfully possesses. For instance, if someone is diabetic and they need a hypodermic to inject themselves with insulin, then that's not an unlawful possession, so that would survive any kind of a charge under possessing a hypodermic instrument. Maximum penalty, once again, on an A misdemeanor is 1 year in the local county jail or probation. Okay. In the little folder you got, there should be a copy of this sheet. Now, just some quick background. In 1973, as a result of a large increase over the previous number of years in drug crimes, the legislature in New York passed a series of drug laws that were signed into law by Governor Rockefeller, and they became known as the Rockefeller drug laws. They were very, very harsh, with certain mandatory minimum prison sentences for possession of even small amounts of drugs. The Rockefeller drug laws were in place for the best part of 20 years, and there was a lot of people who thought that they were unduly harsh. I mean, you could get more prison time for possessing a small amount of heroin or cocaine than you would necessarily for a home burglary or a robbery on the street. So there's been an ongoing movement for the last, well, I guess close to 20 years now, to reform the Rockefeller drug laws. The most recent Rockefeller drug law initiative to pass the legislature and be signed into law happened in 2009. It's created a lot of different penalties depending on the charge, depending on the level of possession or sale charges that are put in place against an individual. And the chart is it's the best one I've come across, and I know that a lot of the judges actually have these on the bench with them, so that it's an easy reference to see what a client can plead to, what the possible sentences will be, depending on their prior record or depending on the amount of drugs that they were arrested with. One of the things that changed with these 2009 Rockefeller drug law reforms was the maximum sentences were lowered, and there's no longer mandatory sentences. Now, at the time, there were a number of people in the drug treatment community who felt that changing the Rockefeller drug laws would essentially take a large incentive out of putting people into treatment. Previously, let's say someone was, convicted of a B felony of possession with intent to sell. They could face, let's say, I think the mandatory was like 5 years. This really gave rise to a lot of the drug court sentences. And the way the drug court sentences would work is this. You've got defendant John Smith. He pleads to a B felony. He knows he's looking at mandatory 5 years incarceration. He's offered a drug court. The way the drug court would work is he would enter his plea in drug court. The sentence would be deferred to allow Mr. Smith to go into drug treatment. If he successfully completed his drug treatment, and the drug treatment terms would run from anywhere from 12 to 18 months of actual treatment, then he would be allowed to withdraw his guilty plea to the B felony. Once his B felony plea was withdrawn, and he would plead to a lesser charge where he might get 5 years probation. Now, the hammer hanging over his head the whole time was if he messed up in treatment, he knew he was automatically going to get the 5 years and he was going to go to state prison. Despite some treatment professionals feeling that a person is only going to do well in treatment when they accept A, that they have a problem, and B, that they're ready for treatment and that they want the treatment, those mandatory prison sentences tended to have the effect of getting someone to that point very quickly, and probably quicker than if they were left on their own. If someone is looking at 5 years in state prison, all of a sudden they kind of come to the realization, well, okay, I do have a drug problem and I really want to get help with it because I don't want to go to prison for 5 years. Once the mandatory prison sentences were done away with in 2009, there was, as I say, some fears that it would take the teeth out of drug court. But the way that's been handled effectively is that judges are now saying, okay, you're pleading on a B felony. I can give you anywhere from 1 to 9 years on that B felony. So even though I'm not obliged to sentence you to a mandatory minimum, I can tell you right now, if you fail out of drug court, I will sentence you to 5 years. So while it's put discretion back in the hands of judges, a lot of the judges are still holding significant prison sentences over defendants, and I think the result of that is we haven't really seen any major decline in people going into drug treatment and people being successful in drug treatment. Let's see. One of the other changes was that probation is allowed now for everything up to, regular probation up to a Class B felony, lifetime probation up to an A2 felony. That wasn't the case previously. So for a client who doesn't have very much of a drug history but finds themselves charged with a B felony, the probation option is a good one, especially if the case is such that either the prosecution is unwilling to reduce the charge from a B felony down to something lower like a C or a D, or the court is unwilling to take a lesser charge. At least with the B felony, there is still the option of probation. And as I said, the drug court is often run with a sentence of probation being imposed on the defendant while they're in drug court. There's also a shock program, which is an option for some defendants who have drug charges who may not be drug addicts or may not have a drug problem. Shock incarceration, for those of you that don't know, is essentially it's a 6-month boot camp type program. You have to be sentenced. You have to be within 3 years of a release date in order to go into shock incarceration. Once you get there, it's a 6-month program of both a physical component and an educational component. So it's usually run like they got up at 5 o'clock in the morning for a 5-mile run. They have breakfast, they have classes, they have more exercise, they have lunch, they have more classes, they have exercise, then they have recreation, and then they're in bed by 8, 9 o'clock, only to start all again the next day. The benefit to it is, let's say you have a client who is eligible for shock. They get, let's say, a 3-year prison sentence. They're eligible for shock. They participate. They can be done with shock in 6 months and released back to the community. Shock was restricted before under the 2009 reforms. It's allowed now for a lot more of the drug charges than it was previously. There's also an alternative to shock program for someone who would be eligible for shock, but due to some physical condition, they wouldn't be able to complete shock. It has most of the components of regular shock without the physical element. I know some prosecutors tend to refer to it as shock light. Another element of the reforms was the judicial diversion program. Essentially, that allowed courts to put defendants in treatment without the consent of the DA. Previously, you would need the consent of the prosecution to get someone into drug court, and that's in a lot of cases. And that grew into the traditional model of the drug courts, where you would have the court, the prosecution, and defense sitting down and agreeing that someone was, once they were deemed eligible, that they were a suitable candidate for treatment. Now, to a certain extent, the prosecution is cut out of that, and the court can go ahead and just order someone that they feel would be a suitable candidate for treatment and order them into a treatment program. Okay. There's a lot of information on that sheet with a lot of footnotes on there. So if you are someone who does drug cases occasionally or even regularly, it's a good thing to have with you, both at conferences or at plea negotiations, so you can see if something is pled down from a possession or a sale to an attempt. You can see the maximums and minimums, and it gives you a range of the options available for your client. Okay, any questions?
Normally more plea-bargain than go to trial? Do they settle normally?
Yes. I mean, statewide, the less than 1% of arrests normally wind up in a trial, but for a lot of drug cases, especially the ones that are like the big sweeps you see that the AG's office does a sweep, or the DA's office or the feds do a sweep, by the time that they make the arrests, they really have mountains of evidence. So the majority of those cases wind up in pleas. But there are cases where drug cases, probably more than others, lend themselves to challenges in terms of motions. In other words, did the officer have probable cause to stop? A field test of drugs on the street is sufficient on the misdemeanor level, but once you get to trial, you really need an actual lab test. And, I've seen it happen. I don't want to say I've seen it a lot, but it's certainly not uncommon where something tests positive in a field test on the street, and it goes to the lab and it comes back as being not a narcotic. So, in a situation like that, to have your bases covered, you would probably want to see, especially if it was a borderline case, you definitely want to see that lab result before you would, start entering into a plea deal with your client. Now, like I said, the field test is enough to get it past, to get the complaint converted into an information and to move forward. But if it's going to a grand jury or going to a trial, you definitely want to see that lab test.
Who presides over a drug court? Is this a trial judge, or is this a special type of proceeding?
Well, for instance, in Albany, there's 2 drug courts. There's the regional drug courts for misdemeanors, and that's Judge Keefe in City Court, one of the 3 City Court judges. On the felony level is Judge Herrick. So it's going to be, on the felony level, it's always going to be one of the county court judges. In Rensselaer County, for instance, it's Judge Jacon. In Schenectady, it's Judge Drago. So it's the trial judge that is presiding over it.
If there's a situation where diversion is included, somebody who's working in the healthcare industry and diverts the drugs, are those two, is the possession and possibly this intent to sell handled separately than the diversion situation, or are they kind of combined?
Well, I think in a situation like that, you would probably, depending on the circumstances, you may see both sets of charges. And obviously, if there was a plea bargain in place, it would probably wind up being a plea to just one set or one element, either the possession with intent to sell, most likely. One other thing I should mention is that mandatory by law, if someone pleads guilty to possession or sale of drugs, their driver's license is going to get revoked for 6 months. It's one of those kind of things that you wouldn't normally think of in terms of drugs, but just make your clients aware of it, and that when the 6 months are up, they're going to have to pay a fee to DMV to get their licenses back. A lot of people think, well, I sit out the 6 months, and 6 months and 1 day later I get in my car, I start driving. Well, now you're going to get arrested and charged with aggravated unlicensed operation. So the other thing is that a criminal conviction in New York, especially for a felony, can render someone automatically ineligible for certain state licenses. One thing I always try to do is in any plea bargain, is to get an agreement, or at least no opposition from the DA on a certificate of relief from civil disabilities. It's not a perfect solution, but it's the only solution we have in New York. A certificate of relief from civil disabilities issued by the court means that the criminal conviction can't result in an automatic bar to certain licenses that someone would otherwise be ineligible for. Unfortunately, it doesn't remove a discretionary bar. In other words, an employer could say, or a licensing body could say, well, we don't have to deny you the license, but we're going to deny you the license anyway because of these additional factors. But at least with the certificate of relief, you're giving your client a better shot at either holding on to whatever state license they may have, whether it's an insurance sales or something like that.
Isn't there also an issue with federal student loans if you have any kind of drug conviction?
There is, and that actually extends down to marijuana, which we haven't been covering tonight because it's in Penal Law 221. Basically, if you've got a drug conviction and you have any federally backed student loans, you're going to become ineligible for those loans for a period of time, depending on the felony. It's not illogical in a sense, but what makes it really illogical is that the same thing applies to someone who's arrested and pleads guilty, or not even pleads guilty, but someone that gets an ACOD on unlawful possession of marijuana. I mean, you get a college kid who's smoking a joint, he gets arrested on the street, he's charged with unlawful possession of marijuana, it's a violation. In New York, under Criminal Procedure Law 170-56, if you're charged with unlawful possession of marijuana, you have no prior convictions for marijuana, you have no prior ACOD for marijuana, you're automatically entitled to a 1-year ACOD on that marijuana charge. Now that falls under 170-56 of the procedure law. A regular ACOD falls under 170-55, and that's for up to 6 months. But the marijuana ACOD, 170-56, you know, most kids jump on it because they figure ACOD, it's adjourned for a year. At the end of the year, it's automatically dismissed and sealed. Mom and Dad don't find out about it. I get away scot-free. Unfortunately, because there's no federal equivalent of the ACOD, the feds look at that kind of backwards. They say, okay, it was a 1-year ACOD. There were certain requirements on you in that 1 year. You couldn't get rearrested, for instance. Well, that's equivalent to probation. And you got the probation on, you were arrested for a drug offense, so therefore you got a drug conviction and a term of probation. And that will render you ineligible for those student loans for a period of the 1 year. The other weird thing is that it can also make someone ineligible to enlist in the military. I've had a number of cases where, you know, guys come to me and they say, you know, I had a marijuana ACOD last year and now I can't enlist. That can be dealt with as long as the ACOD hasn't expired. If it's still within the year, most courts, you make an application to the court to restore the original charge to the calendar, you know, and plead it out to something else. Plead to a disorderly conduct and a fine. At least that way, it's a disorderly conduct and a fine. The military doesn't care about that. But they look at the ACOD the same as the feds do for everything else. I had one case last year where a guy had gotten a marijuana ACOD 3 years previously. Tried to enlist, the military found out about it, and unfortunately there was nothing that could be done because it had already been sealed, dismissed and sealed. The court couldn't reopen the case because they had already dismissed the case and sealed it. DCJS couldn't do anything about it because the court had ordered it sealed. So it was this classic catch-22 situation. You know, the underlying question is, well, how did the military find out about it? They shouldn't have, but they did. So it's something to be conscious about. Whenever I get a client, either with a drug charge or a marijuana charge, two of the questions I always ask them is, are you in college or do you plan on going to college in the next few years? And are you in the military or do you plan on going in? And the answer to either of those questions can have a big impact on the direction we take with the case. Okay. Looks like we're done. Thank you for coming. Have a good night.